She observed the interactions of our three constitutional branches of New Mexico government at a startlingly close range. She continues her public service as an advocate for campaign finance reform, election reform, and healthcare reform. In 2021, she published her third book, it's here on the end of the table, called 10 More Doors. It's a political memoir about public service dedicated to change inside and outside the political system. The public library also owns copies of all three of her books. And with your current and active public library card, you could place those holds today while you're here, if you'd like to. It is an honor for me to be here in the company of these distinguished speakers. Before I pass the baton to Professor Kang, I do want to take a few minutes, like I said, to talk about where to get more information if you want it. So many interesting themes and topics have already been introduced here today. So you may hear some terms in Latin. You may also hear other terms related to constitutional law that are new to you. Black's Law Dictionary is one of the most authoritative sources of definitions of legal terms. This branch library owns a copy of Black's Law Dictionary. It's on the shelf just outside the door, near the road atlases, if you want to know. It's easy to find. It can't be checked out, but it is in our world at the law school, the first place I go when somebody's saying things in Latin that I don't know what they mean. I run over and look them up. The public library system also owns a number of books, both print and electronic, that can guide you through close reading of the United States Constitution. So a recent example, now written for young people, is a title called This Is Our Constitution by Kang. It's so well written. It's really, really also appropriate for an adult audience. It's not the densest prose, though. For something aimed more in that direction, you could take a look at a title called Our Constitution, really similar, by Donald Ritchie, or Seth Lipsky's The Citizens Constitution. These are things that are available through the public libraries. And for a more literary take, there's a fascinating title by Garrett Epps called American Epic, Reading the U.S. Constitution. These are places you can go to inform yourself more. Professor Kang is going to talk about some of the different approaches that lawyers and judges use to interpret the text of the Constitution. Dr. Layden already introduced this idea when she was talking about the RBG's relationship with Justice Scalia, and that they had different approaches. There's a rich literature that talks about these various schools of interpretation and their significance for how the constitutions, both state and federal, are applied to real life situations. So I want to give you an example. I opened the public library catalog on my computer at home last night, and I searched the phrase constitutional interpretation, not fancy, right? And it yielded multiple results. There were books, but the first entry was from something called an electronic source, Salem Press Encyclopedia, a really good article entitled Constitutional Interpretation that had a bibliography with lots of other books that you could follow up on to read more. So the library offers multiple options both here and from your house. You can access quality constitutional information from any computer connected to the internet. Professor Harpalani is going to probably do some compare and contrast or talk about the relationship between state and federal law and constitutional functioning. An annotated version of the federal Constitution or the state of New Mexico Constitution is what will help you develop an even more nuanced reading of these documents. At the federal level, there is a website, it's really easy to remember, constitution.congress.gov. It is my personal favorite source of information, not just the text of the Constitution, history, Supreme Court opinions that interpret and apply the articles and clauses of the Constitution. Dede Feldman, because of her personal experience, is going to talk a lot about what it looks like when the New Mexico constitutional rubber meets the road. If you want that same contextual material about the New Mexico Constitution, it is also available for free. And New Mexico is unique in this. Many states require that you pay quite a lot of money to access a fully annotated version of the state constitution, which is, in my mind, an access to justice problem. Here in New Mexico, we do not have this problem. Another simple website to remember, NM, like for New Mexico, onesource.com. This on the start page has a link called Constitutions, and you simply select New Mexico. They do reprint the US Constitution just in case you need it. You'll find the same contextual information, some history, some explanation of topics, and most significantly, opinions from the New Mexico Supreme Court that interpret and apply the articles and sections of our own Constitution, because the Constitution can't do all the lifting on its own. The courts have that special role of connecting it to real life circumstances. I do have a few handouts, not very many, listing some of the resources that I mentioned today. I also left one at the reference desk at the front of the library. So I'm going to ask Professor Kang to take the conversation now, and thank you very much. I appreciate your kind attention.
Thank you, Jen. I appreciate the kind introduction. And first of all, wanted to say how honored I am to be here today. I do a lot of speaking, but the speaking is exclusively to a group of law school students who are paying money so they can learn a skill to make more money later. So it's purely for vocational and strategic purposes that they are doing that. So it is a pleasure for me to be with the citizens of Albuquerque today to talk about a document that was made in the name of we, the people. What's particularly appropriate about me talking about the Constitution to people who are not law school students, but rather the citizens of New Mexico, is the fact that the US Constitution is the first constitution in the history of the world that was written out. And the reason that it was written out rather than just an idea was because the framers who wrote out the Constitution wanted the common people, the people at large, to be able to read it. And although most people at the time of the founding of the Constitution could not read, the assumption is that this is not a document for lawyers. It's not a document for judges. It's a document for we the people. So it was unique in that way. It was written. It was also the first constitution in the history of the world that was written in the name of we the people. It was an English constitution that preceded it, entirely different idea. It was meant to limit powers, but it was not written in the name of we the English people. So it's a unique privilege to be here for me to talk with you about a document written for the citizens of the United States. So thank you for that. The Constitution is pretty short. If you've never read it, it only contains about 6,500 words. What the Constitution has asked to do, on the other hand, is breathtaking in nature in terms of both scope and time. It is breathtaking in the sense that the 6,500 words are tasked to do the work of creating, number one, the United States of America from thin air. And number two, the Constitution is tasked to do the work of creating the government, limiting rights, creating government powers, and to do this forever, including after the people who wrote the Constitution are long gone. That little document of 6,500 words is about 12 single-space type pages. Has been given to a great deal of conflict over time regarding what it means. The biggest and most unforgettable example of that is the Civil War. I know there's a lot of reasons for why the two different sides in the United States went to war, But one aspect of the war had to do with the fact that there were competing interpretations of what the Constitution was. The South was of the view that the Constitution permitted them to secede from the Union, but the North was of the view that the states did not have the right to secede from the Union. In some ways, it was this conflict over what the Constitution meant that led to war. That's the difference between an English class and a constitutional law class. You could have a difference of interpretation regarding what Hamlet meant, but you're not going to start a civil war as a result of it. So there's a lot at stake in getting the meaning right. And as a civil war suggests, there's always the possibility for constitutional failure. That's what makes the enterprise of the Constitution so exciting and so precarious, is that there's always a possibility for catastrophic failure. What I wanted to do today is to talk with you about what are the strategies for interpreting the Constitution. I'm not going to go over every single strategy. I want to respect your time. Also, I want to hear what you have to say. So I'm going to go ahead and limit my comments. But I want to talk about three of the sort of foremost strategies for interpreting the Constitution. The irony is that even though the Constitution is written, there for you to read, is there for you to go on the website that Jen referred to, constitution.com. But there's so many different ways of reading it. There are techniques that are required to read the Constitution. So there has to be a debate regarding which technique we will use to interpret the Constitution before we even read the Constitution. One such technique is something called textualism. It basically means the text means what it says. To give you an example of what this means, the First Amendment says that Congress shall make no law abridging the freedom of speech. Congress shall make no law. Now, there used to be a judge on the Supreme Court named Hugo Black. He was also the person, if you did not know, who gave the speech at the inaugural of the UNM School of Law 75 years ago. We are celebrating our 75th anniversary this year. And he took a train all the way from Washington, D.C. to come to Albuquerque to offer the address. So Justice Murphy was a textualist. And for him, this phrase in the First Amendment, Congress shall make no law abridging freedom of speech, no meant no. You can say whatever you want. I don't care. Whatever you want. The only limit for him was pretty much speech that was a clear and present danger was not permitted, but everything was okay. I don't know about you, but that makes me nervous. One benefit of textualism is the fact that it provides a degree of clarity. No means no. But at the end of the day, it can't quite do a lot of things. It can't answer questions about just because it's not explicitly in the Constitution, does that necessarily mean we should not recognize it? The right to marriage is not in the Constitution. Heterosexual or gay, not in there. The right to abortion is not in the Constitution explicitly. One more problem with textualism is that with regard to Justice Black, he was very proud of saying that no means no, as far as he was concerned. No law can abridge the right of speech. But if you asked him, speaking of rubber hitting the road, if you ask Justice Black, let's say, for example, selling drugs. If someone offers to sell drugs, should that be protected? Child porn? Is that okay? I'm sure he would say that is not okay. So then he has to rely on something other than textualism to make that argument. And there he has to refer to common sense, morality, and such as well. So those are the sort of the limits of textualism. Originalism is the second sort of technique I just want to approach on just briefly. There's a school of thought that says the Constitution means what the framers said it meant back in 1787, 1789, 1791. There's that school of thought. In some ways, it's very exciting because now you have what the original intent of what the authors thought about the Constitution. There are a couple of problems with that. One problem is that the framers had different ideas. So they had competing ideas of what like the First Amendment meant. Number two, sometimes they would lie in public about what they said about the Constitution. They didn't really mean it, but they said the thing in public so they can strike a compromise with someone with whom they had an adversarial relationship. And it's only in their diary entries and their letters to their wives that you found out what they really thought about the Constitution. This presents significant difficulties for judges and professors because then you have to dig around their letters to their wives and their their non-wives that they had relations with as well. There could be competing views given to both. The other problem with originalism, of course, is that why do we give people who wrote the Constitution 200 years ago the opportunity to live our lives today? They were such different people. Back then, women could not vote. Back then, there was slavery. Such a different cast of characters. America was so different back then. Why give them the opportunity to tell us how we want to live? That said, there are originalists on the Supreme Court. Justice Clarence Thomas is probably the most sort of outspoken originalist. And here's one example of originalism. Speaking of the First Amendment once more, it says that this is a different part of the First Amendment called Establishment Clause. And the Establishment Clause says that Congress shall make no law respecting an establishment of religion. Now, originalists would say the following. It says that Congress shall not establish religion. New Mexico can do it. Number two, establishing religion, an originalist would say, is different from financially funding it. Because back at that time, giving money to churches by the federal government was normal. So we can give money left and right to churches in the United States without establishing a formal religion of the United States of America. That's sort of the originalist interpretation of the First Amendment, or one aspect of it. The last thing I want to talk about is this idea of traditions. That's another way that judges and professors interpret the Constitution. What are the traditions of the United States of America? For example, is there a tradition of recognizing gay marriage? Is there a tradition of recognizing abortion? Is there a tradition of recognizing the right of free speech on the part of corporations? In some ways, tradition is nice, but it also has its limits. What's nice about tradition is the fact that one pays a kind of homage to the past, while at the same time being flexible enough to interpret the Constitution to deal with today's problems. One problem with tradition is the fact that tradition is very ambiguous. Also, traditions are parallel with each other. They're like many different traditions that coexist simultaneously at the same time. It is curious to me, for example, that there have been people on the federal courts, constitutional law professors as well, who've suggested that there is a tradition of gay marriage, and another group of people who have suggested there's a tradition of not recognizing gay marriage. My sense is that probably those traditions coexist together, so it's very difficult to parse them out. There are more different ways of interpreting the Constitution. I just want to share those three with you. Again, it is such an honor for me to share these thoughts with you today on Constitution Day. Thank you.
Thank you, John. Oh, let me get this here. All right. Is that good? Thank you, John. Set up my comments here nicely. I'll start by kind of thinking about the broad ideals of the Constitution. I think, look at the Constitution, very revered document, model for constitutions across the world. But we should also take a critical perspective when we're thinking about the history of the Constitution. John mentioned we the people. We know at the time of the founding really meant white men. A lot of people were excluded from the guarantees of the, okay, thanks. The guarantees of the Constitution. Constitution protected slavery in many ways. William Lloyd Garrison, famous abolitionist, referred to the Constitution as a covenant with death and an agreement with hell. You all have probably heard about the 3/5 clause, whereby slaves were counted as 3/5 of a person for representation in Congress. And that advantaged the southern states who had larger numbers of slaves. 3/5 clause helped protect slavery. Ironically, a 4/5 clause would have been even worse because it would have given the southern states more representation. Original Constitution also prohibited Congress from banning the importation of slaves for about 25 years after the founding, and also had the fugitive slave clause, which required the return of escaped slaves. Constitution started out really protecting slavery. But the good thing about constitutions is that they can change. John talked about the Civil War and different interpretations of the Constitution there. But after the Civil War, we had the Reconstruction Amendments, the 13th, 14th, and 15th amendments. 13th Amendment abolished slavery, except as punishment for crime. 13th Amendment. 13th Amendment is also the only provision of the Constitution that applies to private actors. We need to know that the Constitution is a limit on government power. It's a limit on the different powers of the different branches of government, and also what the government can do in terms of abridging the rights of people. But the 13th Amendment straight up says nobody, not a private party, not the government, no one can own slaves. 14th Amendment deals with citizenship, also applies due process, equal protection to these states, so prevents states from abridging certain rights. The Bill of Rights prevented the federal government from abridging rights. The 14th Amendment is largely about the states, and it's become very important in terms of just protecting civil rights. 15th Amendment guarantees that the government will not abridge the right to vote. So 15th Amendment was really about the right to vote, because that is really the right that is preservative of all other rights. And 15th Amendment is also the only place in the Constitution where the term race is actually used. You know, we think about the Constitution, 14th Amendment protects against racial discrimination. 15th Amendment actually has the terms race, color, and previous condition of servitude. And I wrote an article that deals with race and color, and why those two terms were separated out in the 15th Amendment and other places. So the Reconstruction Amendments really kind of changed how we look at the Constitution, really adjusted the balance of power between the federal government and the states. They really checked state power after the Civil War. Civil War, Reconstruction Amendments. Some people interpret them almost as a new founding, new kind of balance of power between the federal and state government. So, you think about just the structure of the Constitution. You have federalism, this balance of power between the federal and state governments, and also separation of powers, division of powers between the different branches of government, the legislative branch, Congress, the executive, the president, and the judicial branch, the courts. And that's another way the Constitution has kind of changed over time, is that the balance of power between these three branches of government has adjusted in different ways. The way the courts have interpreted the powers of different branches of government. So you think about Congress, federal legislature, Congress. In the Constitution, Congress has limited powers, right? The powers are enumerated, very specific things that Congress can do. It can levy taxes. It can spend money for the general welfare. Congress appropriates funding. It can also regulate interstate commerce. And the notion of interstate commerce has changed a lot over time. You think about going back to the founding versus today. Our economy has become much more national. People go across state lines much more frequently. Goods, services are transported across state lines. So that has kind of increased the scope of Congress's power to regulate commerce, regulate activities across state lines. The courts have also, over time, kind of broadened the definition of what commerce means. What exactly is commerce? Originally, you may have thought of it just as the exchange of goods, but there's a lot of other aspects to commerce, and the Civil Rights Act of 1964 is actually rooted. The way Congress could pass that law is because of its ability to regulate interstate commerce. So Congress passed a law which prevented even private parties from engaging in racial discrimination. The Constitution itself doesn't do that. Congress can pass a law to do that because of its power under the Commerce Clause. So you saw congressional power expand. Executive power has also expanded. As the federal government became more powerful after the Civil War, you see powers of each branch expanding. So the executive branch, the president, there's a lot of different executive departments now. The state administrative laws expanded a lot because the federal government does a lot more. If Congress is going to pass more laws, the executive enforces the laws, right? The legislature passes laws, executive enforces laws, judiciary interprets laws. So you need kind of a bigger executive branch to actually enforce the laws. And, we have a lot more executive departments today than we did at the time of the founding, a lot more executive agencies. President's role in foreign affairs, war powers has all expanded. Each branch of government, likes to have more power. No branch of government is going to say, oh, well, we don't want power. Judiciary also, the notion of judicial review goes way back to Marbury v. Madison, 1803. Supreme Court can strike down acts of Congress that it deems are inconsistent, violate the Constitution. Constitution doesn't actually say that, but the Supreme Court, Chief Justice Marshall, said that that's part of the powers of the judiciary, and we've seen that expand over the years. Also, as the federal government, as Congress passes more laws, the Supreme Court reviews more laws, and there's a whole notion of judicial activism that is critiqued, and whether you support judicial activism or not may depend on who's on the courts, right? Who's going to exercise that power. So we have the different branches of government. In federal government, they've all kind of expanded their power over time. But one thing another thing I kind of want to talk about and think about a little bit is federal versus state constitutions. And I know Dede might get into this a little bit. But so far, we've been talking about the federal Constitution. If you take a constitutional law class, if you learn about the Constitution, in high school, college, or even in law school, most of the conversation is about the federal Constitution, what we've been talking about so far. But each of the 50 states also have constitutions. And they're, set up in parallel ways to the federal Constitution, the three branches of government. But there are some different characteristics in state constitutions and state government, which may affect how we want to think about some of these issues about separation of powers. So I noted that Congress, federal government, has limited powers. They are enumerated. Article 1 of the Constitution lists out what Congress can do. And as I said, regulating interstate commerce, levying taxes, spending, limited powers. State legislatures, on the other hand, typically have plenary powers. They can legislate, pass laws about a whole variety of matters that, aren't necessarily listed in these state constitutions. So state legislatures have a broader range of powers. State judges, you may know, are elected in many states, in the majority of states. That's not true of the federal judiciary. President appoints federal judges and their lifetime appointments. State judges can be elected out of office, and it varies in different states how that happens. Sometimes they're initially appointed by the governor and then sit for re-election. So differences in the state and federal governments. And that has, some implications also. State judiciaries, if judges are politically accountable, if they are going to go for election, that may affect how they view different issues, how they rule on cases. And it also provides another check. Jen mentioned checks and balances. So federal judges are appointed for life. Once they're in office, unless they are impeached, they can make decisions without having to worry about the voters. They can go kind of against the grain. State judges will have to worry about re-election in most states. So there's a kind of political accountability. You can view that as a negative. That means they're susceptible to political pressures, but also if they're doing things that are unpopular, they can be voted out of office. So kind of a different balance of powers there. And one can make the argument also that, state judges, you think about judicial activism. Should judges take a broader role in striking down acts of the legislature? Well, for a state judge, if they do something that the people don't like, they can be voted out of office. So, should that make a difference in terms of how state judges exercise their power? Another difference between the federal and state constitutions, federal constitution is relatively hard to amend. And I won't go through the whole process of how that's done, but it takes, it takes a lot. It takes 3/4 of the state ratifying any amendment. And before that, Congress has to do some things. State constitutions, most states are more easily amended. They can be amended by popular referendum. And that whole process varies state to state also, but you see on a ballot, typical election, you may see several different proposed amendments to state constitutions. So how do we think about that? Well, again, if state judges, say state Supreme Court, makes a ruling that the people don't like, number one, if they're up for office, you can vote them out. Number two, you can get a ballot measure on the ballot. It may be a way to change a state Supreme Court ruling. So does that mean, state courts should exercise more power than, say, the federal courts? There's more checks and balances there? Those are all the types of issues that are debated in constitutional law. So, with that conversation, I think I'll pass it over to Dede.
Thank you so much. I really feel like I've gotten a education going to law school. I never went to law school, but imagine that under our system, there are people like me that never went to law school, but actually were charged with making laws. And that's, that's in some ways kind of the beauty of our system, relying on common sense as well as the letter of the law. I'll talk about a balance of power and separation of powers, which is basically the same at the state level as it is at the federal level, with certain exceptions, as you said, enumerated powers versus plenary powers. Was that the term you used? Yeah, but I just want to get real for a minute here and say that we're having this discussion at a really fragile time in our democracy, and it's a time when 69% of Democrats and 69% of Republicans feel that democracy is in danger of collapse. Now, they feel that way for different reasons, but still, when there is such a distrust of institutions, whether it be the judiciary or whether it be the Congress or the legislature or the president or the governor, that kind of changes the conversation. And we used to, be able to rely on civics classes. Somebody mentioned civics classes here. Well, we don't have civics classes very often in our school system now. And I think that we are reaping the reward for not having it. So thank you to the New Mexico Humanities Council for filling in this gap and trying to translate some of our precious heritage to ordinary people. Now, talking about balance of power and the inherent tension between the three branches of government, the executive, the legislative, and the courts or the judiciary. The underlying question is it working? Is this inherent tension between the three branches of government, is it working to preserve democracy? Or is there something out of whack here? When one branch has more power than the other, or when two branches are captured by one political party, not even mentioned in the Constitution? So let's try to approach that question, I think. But remember, according to the Annenberg Center, 1 in 4 Americans do not know what the judiciary is, what the executive is, and what the legislature is. So they can't name any branch of government or identify what the branches are supposed to be doing. So I think it's time to really kind of go back to the basics and, make sure that everyone knows what the legislature is supposed to be doing in terms of making laws, constructing a budget, what the executive does in terms of carrying out the laws, executing and administering the laws that are passed by the legislature or by Congress, and what the courts are supposed to be doing in terms of, solving disputes between the various branches and applying the Constitution to specific instances. People don't know that. I mean, people are out demonstrating at the Supreme Court in the wake of the Dobbs decision as if those folks were elected officials and could be replaced at the next election. So I think there's a great deal of confusion. But just back to New Mexico and my own stories or experience about this question, does this balance of power system work? or is there something out of whack? So I've had a couple of different experiences, and I'll just start with the present day and the coronavirus. When our governor assumed extraordinary powers in a public health emergency to save lives, and she banned certain meetings. She required masks to be worn in certain instances, and closed certain casinos and restaurants and schools and universities. And that ordinarily would be seen as the executive really assuming the reins, and the other two branches be damned. But what the backstory to that is that the governor was acting under a law that was passed by the legislature. It was the Public Health Emergency Act, and I know something about it because I was the author of it. In 2003, it was passed to give the governor such powers. Remember, that was in the wake of 9/11 and anthrax. And it was specifically passed to allow these extraordinary powers. But they were extraordinary. And there were those who objected to those limitations on individual freedom. And she was taken to court several times by the Restaurant Association, by the Republican Party. And each time the New Mexico Supreme Court said she was within her powers because the legislation had been crafted in such a way that her powers were not absolute, but they were temporary. And if she wanted to constrain individual liberty in that way, she could do it, but only for, I think it was 6 months, or maybe even shorter period. And then she had to renew that again, which she did over 10 times, I think. But that was kind of a balance. And the courts said that she was within her powers. The legislature, there were certain members of the legislature that were not happy about that. And I think it was not this year, but the previous year, there was a move to have the legislature limit the time further when a governor could declare a public health emergency. It didn't go anywhere in the legislature. Now, some of that had to do with the fact that it was a Democratic governor and a Democratic legislature. But that's not always the case. You know, quite often in New Mexico, in fact, only once since the 1950s have we had a Republican-controlled legislature, and it's almost all the other times have been controlled by the Democrats. But we've had Republican governors too. And so just to rewind a little bit further to the governorship of Susana Martinez, that was I think a case in point where we could see the legislature trying to check the governor. The Democratic legislature trying to check the governor using this separation of powers. And when the legislature does that, it has several tools put down in the Constitution where it can do that. One is it in the Senate, where I served, it can confirm the governor's cabinet secretaries or not. Cabinet secretaries are integral to executing the law, to running individual departments. And the Senate must confirm the appointments of the governor in order for that to happen. The legislature can oversee the various departments and, of course, controls the purse strings, which is the ultimate control. And it can also impeach members of the executive if they have broken their law or their oath of office. So in the first instance, the New Mexico legislature did not confirm one of Susana Martinez's appointments, and that was the education nominee, Hannah Scandera. Some of you may remember Hannah Scandera. She was an acolyte of Jeb Bush. Governor Jeb Bush in Florida had a very strong ideas about education and charter schools, and was hated by the teachers' unions. And the New Mexico legislature, the New Mexico Senate, did something that I had not seen before, and that was they didn't reject the secretary's nomination, but they just didn't hear they just didn't hear the nomination for, I think, 4 years. And she was never confirmed. That didn't mean she didn't serve. She just served as an acting secretary. But that really kind of undercut the governor's ability to make policy in the education arena. And the upshot of that, some folks feel, was the suit that was later brought, the Martinez Yazdi suit, which was influenced the spending of money by the legislature and also the policy of the executive. So the other case, even further in the past, was in 2005, when the legislature actually, the House convened an impeachment committee to deal with a scandal on the part of the treasurer in New Mexico, Robert Vigil. Some of you may remember that. It was, in New Mexico, we have several different executives, not just the governor. We also have independent executives in the treasurer and the assessor and the attorney general. So this particular problem was one of embezzlement, corruption, and there was a period there where the legislature was going to have to address this by impeachment, and which was new to me. I had never been through that, and it's very rare. But there was a committee convened in the House, and the preparations were made, but finally, after that pressure was brought to bear on him, he resigned, and later on served time in the, I think it was a federal penitentiary for his misdeeds. So that was, I think, a situation where the system worked, a balance of powers worked. I think the situation where the education secretary was not confirmed was created dysfunction within the government by the fact that the legislature would not confirm that appointment. So now, how can the executive then constrain the legislature? Let's talk about that, because, it goes both ways. And of course, the most common way is through the veto of budgetary matters and regular bills. And in New Mexico, the governor has a line item veto. So the governor can X out certain appropriations. There have been several law cases, again, against Susana Martinez, in which the governor tried to write in just not just crossing out, but writing in appropriations, and that was struck down. But the king of the vetoes in New Mexico, of course, was Gary Johnson. And Gary Johnson was very proud of the number of vetoes that he cast. It was much like a sporting event to him. And my first year in the New Mexico legislature, there was an extraordinary event that happened. I didn't know how extraordinary it was when I was there, but and Governor Johnson had no limit. I mean, he would veto budgets 2 and 3 times, causing special session after special session because we couldn't go on without a budget. Although he at points seemed to think that that was within his power just to continue on after the end of the fiscal year. But in my first year there, which was 1997, was some of you may remember the era of Clinton's welfare reform. Remember Clinton? Clinton was doing welfare reform. He was a middle of the road Democrat, and he had I forgot what his welfare reform was. Required work for the first time for welfare, and so Johnson had a similar but even more draconian program that he put in place. And then the legislature came into session in 1997 and said, we don't like that. We want to do our version of welfare reform. And so we passed a bill, which was less draconian, I would say, than I think it was called New Mexico Progress. And we passed it, and the governor vetoed it, and which we came to expect after a while. And he vetoed it, but then he put into effect again his own plan. And so the New Mexico legislature sued the governor. It sued the governor, and the Health and Human Services Committee, which I was on at the time, was in the lead on this. J. Paul Taylor, who was a representative from Las Cruces, was the named plaintiff, and then there were several others, and they heard it right away. The Supreme Court of New Mexico heard it right away and struck down the governor's plan for welfare reform. And then the governor said, no, I'm going to put my own plan into effect anyway. And so then the New Mexico legislature went back into court, and the governor of New Mexico was held in contempt. It was in December of 1997. And then at that point, the legislature's plan, which the veto had been overridden, and that was put into effect. But one thing that strikes me, and I'd be interested to hear what the professors say, is that there was a tremendous amount of negotiations between the legislative branch and the executive branch. These vetoes and these suits were a way that they negotiated to get a policy that would be put into effect for the next year, or a budget for the next year. And I don't know really is if there is that much negotiation used in court action. It seems to me that that's a part of it, but it seems a little bit more definitive to me. So thanks for listening to us, and we hope that we can trust our moderator to take us home.
See if this microphone's working. If not, I can talk real loud. Thank you so much to the panelists. I hope they raised some interesting questions for you. We have time for questions. So do you guys want to use the microphone that you were using earlier for the questioners, or do we just want to? Yep, here it is. We've got a microphone. All right. I saw this gentleman here in the front first.
Thank you. Thank you very much. Hello? Is it working?
Mhm.
The US Constitution gives war-making powers to Congress. But since World War II, Congress has not exercised that power. They've allowed the executive to decide. And the executives have sent US troops all over the world exercising war powers. There are some feeble attempts to try to get Congress to rein in the executive and to start exercising its own power. Could you give me your opinion on that issue?
Any take?
Yeah, I think, I mean, there is kind of that ambiguity in the Constitution because you're right, Congress has the power to declare war, but the president is the commander in chief of the military, and has power to respond to national emergencies. Now, you're right, the last time that Congress actually declared war was in World War II. But they have authorized the use of military force, like with Iraq, with Afghanistan. It's not quite a declaration of war, but what exactly does that, what exactly does that mean? So I think that ambiguity is, built into the Constitution. I think, it's also very politically difficult for Congress to do much in that situation because we're in a situation of war. There's a perception that there is a national threat. Presidents' approval ratings tend to go up during war, during military action. So there's a whole political dimension here also that once we're in a conflict, it is hard for Congress to really do anything to check there because Congress is a politically accountable body.
I think my colleague Vinay responded to the question very comprehensively. I particularly liked his comment that once war begins, it is very strange and awkward for Congress to say, I did not authorize this because the American public is so behind the effort now. And so I just don't think it's just the nature of war that people get excited by it. They'll support the president. Congress will not get involved in trying to stop the president, and the Supreme Court definitely would not get involved in it. So it just seems now the pattern is such that the president is pretty much omnipotent with regard to sending troops, at least for a while anyway. But excellent question. That was really good food for thought. Thank you.
Okay, thank you. Can you hear me? Yes, my question's for Dede. Hi, Dede. My question is, I understand that the New Mexico Constitution has been amended 70 times. I don't know how many of us are aware of that. And there are actually 3 proposed amendments on the ballot this year. 2 of them really aimed at sacred cows. One, of course, are we going to amend the Constitution to allow us to dip into our general fund, quote unquote, for the sake of early childhood education? But there is no stricture in that amendment saying the money will be used for early childhood education. It could be used for anything until the legislature legislates. And number 2, a way to get around the anti-donation clause. And for the sake supposedly of the 25 feet to the source of power that supposedly is going to help our reservations get broadband, extend broadband through New Mexico, rural areas, and update other utilities. On the other hand, there is no stricture in that saying that developers or Santalina can't use that amendment to receive state funds for development purposes. So my question is, our Constitution seems pretty fluid here in New Mexico. Are these amendments primarily, or how, to what extent, Dede, and all of the panel, do you see these amendments as being ways for various political interest groups to try and assert their influence over our lawmaking capabilities here in New Mexico? Thank you.
Well, there are several questions there. And it is easier to amend the Constitution in New Mexico than it is at the national level, of course, but it's not that easy. In order to amend the Constitution of New Mexico, you have to get a larger majority in the legislature to pass a joint resolution. And a joint resolution has on its face the wording, pretty much the wording that would go onto the ballot. And then if the ballot if the measure does pass at the ballot box, then the next year, and this may be why it's not as that specific, the legislature comes back and enacts enabling legislation that fills in the constitutional amendment. The idea is that constitutional amendments should be broad and general, not specific like laws. Now, in New Mexico, the weird thing is we don't have a popular initiative like most states. And the only popular initiative there is, the only thing that goes to the ballot at a state level are constitutional amendments. So many people have wanted, in frustration usually, have wanted to use constitutional amendments as a way of making change on things that I believe should not go into the Constitution, but have never been able to be passed by the legislature. For example, a minimum wage. A minimum wage for a number of years, there was a move to put a minimum wage, a guarantee in the Constitution, which, doesn't make sense because, inflation and times change and the Constitution is much more permanent than that. So those are just some of the weird things about constitutional amendments in New Mexico. We do have constitutional amendments on the ballot this time. The one for breaking into the permanent fund for early childhood education, that has languished and been proposed in the legislature, I think, for 6 or 7 years. So it's not easy to pass a constitutional or a joint resolution through the legislature. It only takes a few members in the finance committee, for example, to block that. So I don't know whether any of you, either of you, have some comments on that.
You got New Mexico covered.
Well, it's different. Of course, it's different at the federal level where the Constitution has been amended so rarely.
I was going to offer a comment, and I invite my colleagues to correct me if I get this wrong, but part of our federal structure in the United States with my colleagues address the idea of certain powers are enumerated and set aside for the federal government, and the rest are remain with the states in their plenary power. That in fact we see also, and this isn't built into a number of people's sort of affirmation that so much power resides with the state. We're seeing responsiveness. We may not like the response, but the ability to move a constitutional amendment through the legislature, it might take 6 times, but move it through and put it on the ballot is a different kind of responsiveness than we sometimes see at the federal level. And there's complex discussions that happen around how much responsiveness is appropriate, because we've seen in other states policy making going on in the ballot box, and the changes from one election cycle to the next can be rather extreme. So I just wanted to offer that comment as well, that some of this action happening at the state level is simply part of the design.
Yeah, absolutely. I mean, part of the justification, the reason for having, all of these different entities, both federalism, federal, state governments, so this kind of, hierarchical division, but also separation of powers, legislative, executive, judicial power, is that there are many different places for action. And, in constitutional law, we typically, when we teach constitutional law, we divide it into kind of structure and rights, federalism, separation of power, and then all the individual rights. But the two go hand in hand, because part of the theory here is that, if you can't advocate for rights or advocate for other things at the federal level, you can go to the state level. And if we have all of these different branches of government, all these different divisions, there are many different places to go for advocacy. You can go to the legislature, you can go to the courts, you can go federal, state. So, what we're seeing now, after the Dobbs opinion, after the overturning of Roe v. Wade, we see a lot of activism at the state level to try to protect abortion rights in state courts. And, we'll see that for some time to come for different issues, depending on what the law is, depending what the political composition of the legislature, executive, what the courts are like, you can go to one or the other.
At the federal level, one of the things that I've heard and read discussed is that we could convene a constitutional convention rather than going the route of individual amendments. And I'm wondering if you have opinions about the pros and cons of a constitutional convention.
Oh,
I'll offer one. That seems like a real big bite right now. We've got a lot of things on our plates as a country. That's all I'm going to offer.
I'll say what the others are afraid to say. I think it would be a disaster. I think it would be a real disaster. I'd hate to put the Bill of Rights up for a vote, for example. I think that now is not the time for a constitutional amendment when there is a real threat to democracy. And there are so many people that feel frustrated one way or the other do not trust elections and would like to change things drastically.
Why don't we have the Bill of Rights? Didn't they comply of Equal Rights Amendment? Didn't they comply with all the rules in the Constitution? I heard that there's one unelected person who's holding that hostage, who's an archivist or something, who's supposed to decide whether putting that time limit in was valid or not. No other amendment had a time limit. The required number of states have ratified it. It seems like we ought to have it, Equal Rights Amendment.
I agree.
I think that's a very good question. I'd like to hear the answer to that too, as to why we don't have it.
Yeah, because it was just one state short back in the 70s. Yeah. Yeah. And I mean, you're right. The argument is that the time limit expired. That is it, like many questions in constitutional law. I mean,
Well, who controls that? That's I think that's your question, Michelle. Who controls it? Why is it blocked? Do you know? And does anyone know?
But if the text was there, the question remains, what is the mechanism to decide if the timeline text was appropriate or inappropriate? And I think perhaps we do not know.
Ultimately, it would be the U.S. Supreme Court. Yeah.
All right, yes.
I'm going to backtrack just a little bit. I'm not exactly sure. Can everybody hear me? Okay. I'm not necessarily sure what exactly is a constitutional convention. And once I heard her question, it seemed as if there was a lot of tension with that. So what are the pros and the cons of a constitutional convention?
Well, we've had one in New Mexico. Here's the case. We've had one, it's to rewrite the Constitution. It's to rewrite the Constitution entirely, rather than piecemeal amendments, just start from scratch and write it to fit modern day, let's say. That would be the theory that would use. In New Mexico, we had a constitutional convention. I think it was 1969, something like that. And we had it, I think Bruce King, former Governor Bruce King was the chairman of the convention. And it went through, it modernized the government to a certain degree. I think maybe gave the executive some more power. And I don't know all the details of it, but, constitutions have, really outdated provisions in them. I mean, in the New Mexico Constitution, they said idiots can't vote, foreigners can't own property, stuff like that, and so we've tried to over the years amend those out, but it's not always possible. This thing about idiots, I think it passed several times. So so the idea is to start from scratch and do something that is agreeable to a lot of people. And that was done in 1969. It was put to the voters and it failed. It failed narrowly because the provisions were that it had to get over a majority. See, this would be the case in a constitution. It would be hard. You can see why it would be hard to start from scratch and, set up a new government. We might want to set up a socialist government, or we might want to set up a government like they have in England. Pardon? Or a parliamentary system. Yeah, so in New Mexico, it didn't pass because it had to have, I think, not only 2/3 of the counties, but 2/3 of the vote in all counties, and it didn't pass muster that way. But I don't think that answers your question. I'm going to pass the buck here.
I'll say, part of the reason for having a constitution is to bring kind of stability to government and law. This is kind of the most important, most supreme document that organizes government, that, lays out the powers of government. So, anything that would kind of radically alter that, convention, anything like that. I mean, it has a great destabilizing potential. Now, at the federal level, if you had a constitutional convention, it would be the state legislatures who convened that, who selected the delegates for that. And if you think about just, different state legislatures around the country, depending on, what you want to happen with amending the Constitution, that could really, change things in theory. A mechanism that would radically alter the Constitution could be destabilizing for the government, people's understanding of the government, and is kind of an extreme measure. I mean, you go back to like the Articles of Confederation. We were having major failures, before the founding, so it was deemed necessary, and under those circumstances, and we may be headed for those circumstances, unfortunately, the way things are going. But it's kind of a thing of last resort.
One thing that I'd like to reiterate is, under Article 5 of the U.S. Constitution, there are the procedures for how to amend the United States Constitution, either by convention or by state legislature, your choice. Very difficult to do under either one. And the reason the framers made it extremely difficult to do is because, for the reasons that Vinay had stated, you never know what you're gonna get. When the people decide to amend the Constitution, they may think that if I make this, I am going to get that thing. But once they amend it, it's not going in that direction at all. It's going in the opposite direction. And also, you have to remember that all the other amendments have to live together as one family. If you have one amendment in the Constitution jostling in an extreme tension with another, this could lead to all sorts of unintended consequences. One thing I will also like to reiterate, two things actually I'd like to say. the chief way by which the United States Constitution is amended is not through Article 5. That happens once in a lifetime, maybe not even once in a lifetime. The chief way that the United States Constitution is amended is by the United States Supreme Court. The way they interpret the Constitution is a form of amending the Constitution. I'll give you an easy example of that. There was a time back in 1973 where the US Supreme Court, out of nowhere, stated that under the 14th Amendment Liberty Clause interest, a woman has a right to reproductive freedom, a right to an abortion. That never existed before 1973. The court, in effect in 1973, had amended the 14th Amendment Due Process Clause. And again in 2022, the United States Supreme Court had one more time amended the Due Process Clause by stating that a woman does not have the right to abortion. So if you're wondering, how can I amend the Constitution? It happens every day. You're just not the one who's doing it. The second thing I like to say, this may not be very obvious, but I always find it to be very moving. I wrote a recent law review article on this in the New Mexico Law Review. Before the Civil War, Frederick Douglass, still in my opinion, the greatest African-American leader and a great American in general, was a slave living in Maryland. At that time, the Constitution did not recognize people who had been slaves as being citizens of the United States of America. He could not count on the amendment process in Article 5 to recognize him as a citizen. That was never going to happen in his lifetime. He also could not expect a racist US Supreme Court to recognize him as a citizen or a human being under the US Constitution. So he amended it in a very different way. He started reading the phrase "we the people" in the preamble of the United States Constitution as including him. And he lived this life saying, I interpret the Constitution for myself. Because nothing in the Constitution per se says that the US Supreme Court has a higher authority over him in terms of interpreting the Constitution. A radical concept that we the people, today's very apropos of Constitution Day with we the people here, it's very apropos that we the people get to interpret what the Constitution means for ourselves. I always find that to be extremely moving. That's another way that the Constitution was amended. It's a one-man amendment, but he lived his life according to that.
So I have a question. So I will occasionally find myself in conversations with acquaintances or friends or even family about, the Constitution or a specific element of the Constitution or debates over court cases, relating to the Constitution. And unfortunately, some of the response that I get from the folks that I'm talking with, and it's troubling, is that the response of why should I care, right? Like, why should I care about that? I think it goes along with kind of a general anomie, maybe around things that are political or things related to governance. And so I'm wondering if each of you could take a stab at explaining why you think it's important, why the Constitution is important, and why we should care.
Constitution affects all of our lives. I think of, while you're asking a question, first thing I thought of was, Brown v. Board of Education. That case was not just about Linda Brown, the plaintiff. Whatever the decision that case was going to be was going to affect millions and millions of children across the country. And we've seen that, not just, with the ruling and, school desegregation. Ironically, schools today are still pretty segregated. Brown v. Board of Education probably had its least effect in schools, but it galvanized the civil rights movement. It's no coincidence. Brown v. Board of Education was 1954. The Montgomery bus boycott, when Rosa Parks refused to give up her seat, was 1955. You know, she knew what was going on. NAACP knew what was going on. 1964 Civil Rights Act. So, the Supreme Court ruling prompted a lot of other things that happened and really, broke down de jure segregation, affected our society in ways, that were profound and really touched all of our lives. So I think, the Constitution, the way it's interpreted has that broad effect and can have, impact on our everyday lives.
I'll just jump in and read to you from the young adult book that I brought with me. Because the author, Mr. Kang, is an immigrant and a lawyer for whom I have tremendous respect. He talks about the vision of Thomas Jefferson and the words of the Declaration of Independence, a truly revolutionary statement of faith in human equality and a firm rebuke of tyranny. And what Mr. Kang tells us is the way those ideas are translated into the rule of law and a real country. And not only that, but how they transmit from generation to generation is through the Constitution. That it is flawed, as humans are flawed, but it is the way we pass the values. So if the founding values are important, having a mechanism to implement them and pass them on must also be important. That would be my answer and Mr. Khan's answer.
I heard that the Bill of Rights were taken up also by legislatures. So even though it says Congress shall do this, it in effect, really, it's been extended to all the states for most of them. Is that true?
Yes, gradually over time, most of the parts of the Bill of Rights have been extended to the states, and that's been done through the 14th Amendment's due process clause. What the courts have said, and this happened like one amendment at a time, it didn't happen all at once, that, the 14th Amendment is a limit on state power. So basically, the court has said due process includes different parts of the Bill of Rights. There are certain provisions that have not been, such as the Third Amendment, federal government can't force you to quarter soldiers. No case, that's not something that's come into play a lot. So that, has not been incorporated against the states, but much of it has.
Ma'am, if I can just elaborate on that. Short answer, yes, most of them have been applied to the states. They've been done gradually and not all of a sudden, based on the idea of ordered liberty. Like an easy example is that the Sixth Amendment requires the establishment of public defender offices, which costs money, taxpayer money. It's hard for some states to even create a public defender office. So over time, the federal courts, the Supreme Court had to think about, would it be fair to the states to require them to set up a public defender office, especially poor states? And over time, they thought, yeah, it's probably a good balance between making sure that people who are accused of crime and making sure that a state that is otherwise poor and has poor legal infrastructure can accommodate that. So over time, it was done.
I was interested in, with all these traditionalists and originalists and absolutists on the Supreme Court, I guess they've in effect amended the Constitution from the Second Amendment, when you're supposed to have a muzzle loading musket, to now advocate for everyone to have a semi-automatic weapon of war in their possession at all times. This seems to me that they have really overreached, and somebody needs to slap these guys down.
I think it just reinforces the message from the first presentation, as well as the themes here, that the way you think about and interpret Constitution is critically important. Professor Kang introduced us to some of the schools of thought. There are many more. And this, we can point to the Constitution and say, yes, that's it, that's the thing. But this act of interpretation and application is hugely significant. Somebody? Here's somebody with a question. Okay.
I'm not good with this. I'd like to go back to 2 or 3 questions and your answers of before. It seems to me that you, because I want to check on this, have stated that the Supreme Court now has defaulted to be the agent of change, so to speak, for the Constitution. Couldn't one argue that that is serious overreaching on their part and that they are impinging upon, say, authorities that are due to the legislature rather than to remain just with their own prescribed duties of the Supreme Court?
Yeah, I like the question very much. If I can make an observation that it is obvious to common law professors, but may not be obvious to the general public. All of the rights that we cherish now, including how we think about the First Amendment, a woman's right to reproductive choice, the right of association by unions and civil rights organizations, all of those rights were recognized between like 1964 to 1978. I want to repeat that one more time because it may seem startling to you. The Bill of Rights were ratified in 1791, but it was not until 1964. So I believe the Beatles had just landed in the United States at that time. Until 1978, until I believe the Beatles had just about broken up at that time. That all of the rights that Americans love and cherish were born. And the reason it happened during that time was because, number one, you had a very unique cast of characters on the court, which were never replicated again. Number two, you had the assassination of President Kennedy and Reverend Dr. Martin Luther King Jr. And the assassination, of course, of Bobby Kennedy. So 3 iconic liberal leaders were killed. President Johnson was in charge, a unique cast of characters on the court. So it was between 1964 and 1978 that all the rights were recognized. And starting from 1978, we're done. It's over. We're not going to do that anymore. A new cast of characters is on board. Kennedy, Dr. King, those are memories long gone. Doesn't matter anymore. Ronald Reagan is in charge now. President Nixon is in charge now. So with regard to that, ma'am, I think that for taken in the long sort of history of the United States, the burgeoning of constitutional rights was just a couple of decades in the 1960s, and it never really happened again. And my hunch, 2 years ago, I don't take any pride in this, but 2 years ago, one of my students had asked me, do you think the Supreme Court will limit a woman's right to abortion? And I said 2 years ago, in the summer 2022, my hunch is they'll get rid of it. All of it. My hunch is that within the next 5 years, the right to gay marriage, other associated rights, those are not going to exist within 5 years. It's a brand new cast of characters on the court. And ma'am, I really like your question a lot. The broader philosophical question you're asking is it okay for the court to recognize these rights to begin with? The justices on the court now, they were law school students like in the 90s and the 80s. And those students who were conservative, who were on the Federalist Society, they were filled with rage at seeing all of this stuff happening. Now they're federal appellate court judges and they're going to take it out. That's what's going to be happening because they're in their 50s. They're going to change the scope of the United States Constitution. My students' children, if they go to law school, will be living under a very different constitution than what I grew up with. That's my hunch.
Now, we are very close to time. And we've all just been on a very significant emotional journey with Professor Kang. And I want to point out, though, picking up on a theme from earlier, we have a New Mexico Supreme Court opinion relevant to one of the topics he brought up, which is same-sex marriage. So we can see that it isn't always as clear-cut as something changes in the Supreme Court, so everything changes. There is this complexity of what our state has to say. The question would be then what other states have to say. I also want to remind you that in a number of things that we have brought up today, the Second Amendment and the right to bear arms, other things that appear in the Constitution can be guided and limited by our legislative branch. And I would argue one of the characteristics, certainly of my lifetime, has been to a certain extent a lack of activism in our legislative branch around some issues. And that can create the kind of balance against what some people might argue is an activist Supreme Court. Yeah. All right, thank you so much for your time. Thank you to the panelists. Thank you, New Mexico Humanities Council. We appreciate you.